So I wanted to go through just a couple of the issues that come up when injured workers have more than one date of injury. If you have multiple injuries when you're at work, it can impact a number of different parts of your case. So let's say you're working at your job with the employer, you get hurt in January, you start treating with a doctor, maybe you miss a little time from work, you come back to work, your months go by, and in June you have a new injury with the same employer. So what are some of the issues that come up? Number one, treating physician. If you like your treating doctor and that treating doctor can treat you for both dates of injury, that can work. You can see the same doctor. The doctor may write two different reports, one for the first claim and a second for the second claim. And I've even seen some doctors have you come on different days. One day, especially let's say if the January injury was a knee and the June injury was a wrist, if they're very different, the doctor may want to see you on different days. It's also possible that you have different treating doctors for the two different claims. So if you're treating, let's say, with a podiatrist for your January injury because you hurt your foot, and then you injured your wrist in June and you're treating with a wrist surgeon or a hand surgeon, it is possible that you have two primary treating physicians, one primary treating physician for January and another primary treating physician for the June injury. Another thing that comes up, you're generally entitled to 2 years of temporary disability, up to 2 years. If you're off work for the two injuries at the same time, and you're off work due to both of them together, those temporary disability periods will generally run concurrently, so they go together. You're using up your temporary disability on one injury and also using it up on the other. But something to keep in mind, let's say you get hurt in January, you're off work for 3 months, and then you go back to work, and then you injure yourself in June. That new June injury is going to open up a new window of temporary disability for up to 2 years of temporary disability for that injury. So you've already used a few months for your January injury, so you only have, let's say, up to 21 months left for that injury, but you do have 24 months left on the new injury. What else comes up? Let's talk QMEs. So the QME, when you go to see a QME, generally needs to address all injuries with that employer that have occurred up to the filing of a claim form. So let's say January you get hurt, you file a claim form, you're off work for a little bit, you go back to work and you request a QME. You go to the QME, let's say in May, you're back at work, you've seen the QME, the report's pending or it's going to come out soon, and then in June you get hurt. In June, when you get hurt, that's filing, you're going to file a claim form after you already saw the QME. So because of that, you can get a new QME for that new date of injury. You don't have to go back to that same QME. So if that first QME writes a horrible report and you just can't stand him or her and had horrible bedside manner and you want to get a new QME, you have every right to do that with the new date of injury. So a slightly different twist on the facts though, here if you get hurt in January, a few months go by, you're off work, you come back to work, you have not seen a QME yet and you get hurt in June, now because both of the claim forms have been filed before you saw that QME, what's generally going to happen now, when you see a QME down the road, he or she has to address both dates of injury. So you're going to see one QME and that doctor is going to address both because what matters is the timing of the claim form. That QME needs to address all the injuries that have been filed, all the claim forms that have been filed up to the time of that exam. Another issue that comes up with multiple dates of injury, when you resolve the claim, you're generally going to have different sets of stipulations with request for award for each date of injury. So if you're still working at the employer, you got hurt, you were off work, there's some permanent partial disability, you got hurt again, you were off again, some more permanent partial disability, but you stay with the employer. They can accommodate any work restrictions, you keep on working. You'll generally see two sets of steps, one for the first injury, another set of steps for the second injury, just because trying to mash those onto one document gets messy. I will say, if you're no longer employed there, or if the employer can't accommodate the restrictions and you enter into a compromise and release, it is much easier to put both of those into one document. So multiple dates of injury, if you're resolving them with stipulations with request for award, you're probably going to have one for each date of injury. If you're resolving them with a compromise and release, a C&R, you're probably going to lump them all together. If you like this video, hit the like button down below. And if you have questions for us on this topic, drop us a comment and we'll see if we can't answer those questions or maybe make another video.